But Sean, it's turning into a crazy Halloween today. Now that I didn't think. All right, Mr. Jackson, we're gonna see what's going on, all right?
Okay.
Thank you for dressing appropriately for court.
You're welcome, ma'am.
Always keep your head up when you speak to people, okay?
Yes, ma'am, but really, I don't want to be on camera.
Mm-hmm. What page is he on the docket? Ah, all right, he has a warrant. Why does he have a warrant?
Because the bail bonds made a mistake.
No. Asking second chance.
Oh, he had a warrant from August. We hadn't received any payments from him since March. We had to issue a warrant in August. But he did come back and make a payment. So we've been trying to restore the bond since August 28th. We've tried to restore the bond.
Just 1 second. Let me explain something to you. You have to put on your listening ears. Do you not hear? It sounds like she's trying to get the warrant pulled so they can be back on your bond.
Now that's why I raised my hands.
So here's the thing. We don't need you to raise your hand right now. Right now, she's trying. Man. Here's the thing. She's trying to say she wants to be back on your bond. Do you not want her back on your bond? Because if you don't want her back on your bond, you can be taken into
consideration. It's a mistake, ma'am. I understand y'all doing your favor. It's a big mistake.
He can go.
All right, I can go there.
He doesn't want you back on his bond.
Okay, am I excused?
Yes, you're excused.
Thank you. Have a great day.
You're welcome.
I know. Thank you. I don't understand that guy.
It's Halloween. Happy Halloween.
Happy Halloween.
Maybe it was a trick.
Yeah.
Oh,
See, that's what's going on.
Should have chose the tree instead of the tricks.
And you know what? It's like, even if somebody made a mistake and your freedom is at stake, the time to get upset about it is after it's corrected, because it sounded as though they wanted to get back on his bond. And
so sometimes you tell the client, this is a hyphen situation. They go, what? Shut up.
All right, court is calling 2024 CR 008302. 2024 CR 008303. State versus Keith Darnell Jones. Can I have parties announced for the record for the state? Defense?
Sharon Thorne's the defendant, Your Honor.
And are you Mr. Jones?
Yes, ma'am.
All right, you entered a plea bargain in each of these cause numbers. The defense waived the PSI, and Mr. Jones also waived the PSI, and we're going to proceed with the court reviewing the TAP evaluation. In each cause number, the client entered a plea of no contest, and the cause number ending in 03, the repeater offender allegation was waived. Have both parties had a chance to review the TAP evaluation state?
Yes, Your Honor.
We have, Your Honor, and I've gone,
Okay.
and I've gone over, I have, Your Honor, and I've gone over with my client.
Any objections?
No objection.
That's right. So everyone, if you all not talk behind the court reporter, and if everyone can please whisper. I know today is supposed to be a frightful day, but let's not make it frightful for the court reporter by talking loudly. All right, in each cause number, according to the plea bargain agreement, punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. The state is opposed to your application of community supervision. The cause numbers are to run concurrently, and they're taking 2 cases into consideration. State, do you have any witnesses?
No, Your Honor.
Defense, any witnesses?
I would just call my client, Your Honor.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record, please.
Keith Jones.
All right.
Thank you, Your Honor. Mr. Jones, we're here today for the judge to assess sentencing in your cases. You understand that?
Yes, ma'am.
And you understand all the cases that are being taken care of today and also the ones that are going to be dismissed.
Yes, ma'am.
Okay. You asked the court to do what's called a TAP evaluation where you talk to the drug counselors prior for her to do the sentencing. Do you remember that?
Yes, ma'am.
Okay. And do you remember what it is that you talked to them about just recently?
Yes, ma'am.
Okay. In your meeting with the drug counselors, my understanding, you're telling them that you don't have a drug problem, but that you do admit that you were selling drugs. And you understand that this judge has a wide range which she can do. The offer is 10 years. She could either put you in prison for 10 years or she could give you probation for 10 years.
Yes, ma'am.
You're asking this judge to put you on probation. Can you tell the judge why you're asking her to give you probation?
Yes, ma'am. My mom, she's very sick and there's no one there to help her. And she leave me there with her. And I know I can do better. I know I messed up.
But
And
let me ask you this, how long has your mom been very sick?
it's been about 6 months.
All right, so why would you put yourself in this situation to be going to prison knowing that your mom may or may not need you?
It was just had to make some money.
Why not get a job?
It was just didn't have enough time.
Oh, sure, there are plenty of places to work.
No, I mean, at the time, I needed quick money and
Why did you need quick money?
Because my pockets was flat and we couldn't eat.
Oh, they have places where you can get food for free.
Just now.
And who is this we could not eat?
Well, speaking of me, my mom had food in the house, but me and myself, me.
All right,
Yes, and so at this point, you understand that the judge has total control of what she can decide to do.
Just now.
Other than your mother being sick, what other concerns do you have and why you're asking this court to grant you probation?
But I know I feel it above my head, but I know I can do better.
Do you think that you could comply with the terms and conditions
Just
of
now.
probation?
I know I can.
You'd have to report once a month. You'd have to stay out of trouble.
Just now.
You can't hang around with people who sell or use drugs.
Just now.
And you can't sell or use drugs yourself.
Right.
But you feel that you could comply at this time in your life.
Just now. I know I can.
Pass witness, Shawna.
state any questions? All right. So what is his criminal history? Yes, please. Defense, any objections to the court reviewing the criminal history?
No objection, Your Honor.
All right, court will hear argument. State you're opposed.
Yes, Your Honor. We're opposed due to the one to without this. Prison time, right?
All right, defense.
Your Honor, we understand he has a very long checkered history. We are asking you to think outside the box. He is asking for probation. He does have family he needs to take care of, and we are just asking to show some mercy and to grant him probation.
All right, Mr. Jones, I will tell you, it is very rare for the court to see people admit to selling drugs and saying, no, I don't have a drug problem. I just sell drugs. At the same token, people will come before me, and you've come before me, and you said there are other people that you need to take care of. People need to think about that before they do wrong. You understand?
I understand.
All right. This is what the court is going to do. The court is not going to grant you probation. The court will sentence you to a $1,500 fine, and the court will sentence you to 9 years in the prison. Give you credit for any time served. And the cause number ending in 303. Court will find you guilty. The court will sentence you to a $1,500 fine. Time and money will run concurrent. Sentence you to 9 years in the prison. Give you credit for any time served. This will run concurrent with 2024 CR 008-302. Taking consideration 2024 CR 008-299 and 2024 CR 008-301. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and sign it?
Yes.
All right, because these are plea bargain agreements, because I followed your plea bargain agreement, I've actually given you something less than you bargained for. And because you waived your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. You are at a point now that if you pick up any new felony charges, depending on what type of felony it is, you're looking at a minimum of 25 years. And I will tell you, people say, oh, the jail is overcrowded. Oh, the prison is overcrowded. Guess what? People will always build new prison. They'll always find space for you. And if a cell is only supposed to have 10 people in it, if they need to put 20 people in that cell, they're going to put 20 people in that cell, whether it's a violation of federal law or not. You understand?
Yes, ma'am.
So if you love your mom, like you say you love your mom, then you need to stop doing this because you're breaking her heart. You understand?
Stand.
All right. Good luck to you. Okay.
No, thank you.
You're welcome.
Thank you, Your Honor. Maybe excused.
He has some dismissal, so he'll have it. And thank you for always being respectful.
Yes, ma'am. Thanks.
Hey, everybody. Welcome to American Courts today. I want to thank everybody for coming out. Thank you so much for the moderators. It's good to see you, Sivo girl. She had a few things going for her. I don't know if that delays back or not because I can't look at myself while I'm talking. It looks weird. So thank you guys so much. Make sure you guys check out Court Vibes Discord and check out how they're all dressed up for Halloween. That was funny. I was really impressed by that. We got Judge West, Judge Boyd, Judge Fleischer today, and then I think we're gonna do Court Addict at 9. It all depends on if Allie wakes up or not. I'm not sure. All right. Well, let's see if we can mess up the delay. We're gonna run over to. Let's go to Judge West. This one's a little bit longer. It's about 30 minutes, but it's entertaining to watch this inmate. This is about a month old. I wasn't able to get it out, but we got it out today. So let's see how it goes.
Okay, so Mr. Segur, when you were here and entered your plea of guilty, I asked you some very specific questions about pleading guilty freely and voluntarily, and then pleading guilty because you actually did what they charged you with, and your answers to both of those were yes. The version, however, that of your version that I received here in the pre-sentence report is a little different. It says that you didn't have the drink until your vehicle was stopped. And so your version, if I'm to believe it, is that you stopped at the Taco Bell.
Yes, ma'am.
You drove to the Taco Bell.
I drove to the Taco
You
Bell.
stopped at the Taco Bell and you drank while your vehicle was stopped.
No, ma'am. I was outside the vehicle when the officer.
So you hung out at Taco Bell.
I was
and drank.
I was waiting for the line to move so I could get my food.
I asked that the defendant be sworn.
Yeah. Let's do that. Raise your right hand. You
Yes.
swear or affirm that the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
So help me God.
Okay, so you're saying that you got to Taco Bell. You drove to Taco Bell,
Yes, ma'am.
okay?
I made a right turn with my signal and everything. Then I was about to park my vehicle.
Mhm.
That's where the swerve came in at. Okay, obviously it has to be. And then so,
I'm not worried about, let's,
Oh,
hold
yeah.
on.
yes, ma'am.
All right. I want to know, when you got to Taco Bell, regardless of whatever happened,
Right.
did you go through the drive-through or
No.
did you park?
No, ma'am. No, ma'am. I
Listen to
parked-
my question. Did you go through the drive-through or did you park?
I parked my
Okay,
car.
so when you parked your car at Taco Bell, you start having alcohol at that point?
No, ma'am. I got out of my vehicle to see how far traffic was up in front of me.
Okay,
They had several cars in front of me. I
in
wasn't
front of
even-
you for what? You were parked.
Yeah, I was parked like,
Were you parked in a parking spot or were you
No,
parked in
ma'am.
the drive-through?
I was not exactly in the drive-through. I was at the end of the store, at the end of the store.
Okay,
But I guess you could consider that the drive-through line.
were you waiting for the drive-through?
I was waiting for the drive-through to
Okay,
proceed,
listen,
because-
here's the thing. You're not gonna try to trick me up with semantics
No,
today. Hold
ma'am.
on, don't talk over me.
Yes, ma'am.
When I say, were you going through the drive-through or were you parked? What does that mean? That means, did you park your car because you're going to go in the store, or were you waiting in the line to go through the
I was
drive-through?
actually waiting to go through the drive-through.
Okay. I may look, I don't know, like I'm 12 years old and just fell off the
No,
turnip
no,
truck,
ma'am.
but I'm not.
No, ma'am. I'm
So
not.
you're in the line and you get out of your vehicle, right? Because
Yes,
there's a long line, the
Right.
cars aren't moving.
right.
Right. So you get out and you decide, I'm going to start drinking here in the parking lot.
No, ma'am, I didn't drink until I got back inside my car.
Okay. But while you were at the Taco Bell, you started drinking. Had you drank before that?
No, ma'am.
So you're telling me that you started drinking at Taco Bell?
Yeah, I opened the container. That's how the beer came. It was on the floor.
So
of the
from the
vehicle.
time that you started drinking at Taco Bell to the time that the officers got there, about how long was that?
Oh, maybe 15 to 20, 30 minutes, whatever.
Okay. How much did you drink between that time?
I had a malt liquor. The
Mhm.
211 is a strong beer.
Just one?
It was a 40 ounce.
Right. So you drank the whole 40
I was
ounces.
drinking out of the thing. After the fact that
You were drinking out of what?
after I stepped back in the car, I started drinking.
Right.
And
So
then- so
how much of it did you drink?
I consumed a lot of it,
Okay. So let's just say you drank most of
most of it.
one 40 ounce.
It was getting contained.
So that's your story and you're
I
sticking,
sang
hold
beer.
on. So is that your story and you're sticking with it, that you drank most of one 40 ounce beer in about 15 to 30 minutes and that
Yeah.
you hadn't drank anything before then?
No, except for that night before, about 2 o'clock that morning. And
Okay.
then whole blood, alcohol stays in your blood system, added to what I drank.
Okay. So your test on this night after drinking most of a 40 ounce was 0.188. And you're wanting me to believe that that's based on most of one drink, and that maybe you still had alcohol in your system from the day before.
Yes, ma'am,
Okay.
but what I recalling my memory, ma'am, I have no reason to try to trick you, Miss West. I'm telling you the God's honest truth. Like I said, I had alcohol in my system from the night before.
Well, how much did you drink the night before?
Well, I was intoxicated.
So what you're telling me then, if
And
you
hold-
had, hang on, so if you had that much alcohol in your system from the night before, that you were still probably hold on. Watch where your story's going.
Yes, ma'am.
So you're telling me you had so much in your system the night before that it was going to still be in your blood, and you had just driven to the Taco Bell.
No, I drove into the Taco Bell that later on that evening,
You're not right.
but it wasn't a full 24 hours,
Right.
right?
So if you're saying that 0.188 is because of the night before, then all likelihood you were drunk when you were driving from the night before, if I'm to believe your story that you only had most of one drink while you were there. See how that doesn't make sense?
Yes, ma'am.
Okay. All right. So let's go back. Obviously there's some medium acceptance of responsibility, so we can go forward with the arguments unagreed. Mr. Burbank, I'm sorry, Mr. Coleman, you have a witness?
Yes, Your Honor, State Cause Troy Robinson.
Mr. Robertson, if you please raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Your Honor, the court's familiar with Mr. Robinson and his background, but for
Sure.
the purpose of the record, Mr. Robinson, you're certified as a fingerprint expert. Isn't that correct?
That's correct.
How long have you been certified as a fingerprint expert?
Almost 6 years now,
Testified in court before?
multiple times.
You've had an opportunity to review some documentation in this case.
I have,
Did they include prior judgments for the defendant, Mark Anthony Segur?
they work.
I'm showing you what's been marked as State's Exhibit Number 1. Is State's Exhibit Number 1 a fair and accurate summary of the 20 previous felony judgments that you reviewed in this case?
It is.
Using your,
For 20 felony judgments.
I apologize, 20 previous prior criminal judgments, including a number of felonies.
Correct.
Okay, I mean, in other words, both misdemeanors and felonies.
Yes, sir.
And did you use the defendant's admission to at least one of the DWIs that he pled true to that had a print on its judgment to compare to the judgments here that had prints on it?
That is correct.
And what was your determination?
They're the same person.
And in addition to the prints that you used to compare and confirm his identity on these judgments, were there also some personal identifying information such as date of birth, SID numbers, and that kind of thing that you used to link to this?
Correct. As known as that part.
Okay. Your Honor, at this time, I would offer State's Exhibit number 1, which is a summary of the judgments and the actual judgments themselves that are marked as State's Exhibits 2 through 20. For purposes of record tender to defense counsel.
Let me just ask, are there any on that list that aren't already on the pre-sentence report? I mean, why are we
It's
doing
been a while
both?
since I looked at the judge. I did think that there was at least a couple of those judgments. It's been a while since.
Mr. Burbank, does your client,
I'm gonna,
hold on, does your client have any objection or any reason not to, for me not to take judicial notice of the PSI for sure, that those prior offenses listed in there and the ones that are convictions are any way wrong?
for the misdemeanors, that's correct.
Okay, so what about for the felonies? Is there one, are there one or more that are, he contest?
It's catch-22, Judge.
Okay.
Because he's pled not true to them so that you'd have the full range of punishment.
Oh, okay, so,
Yeah, so
So-
it's the 2 felonies that I think are crucial here.
all right, so then do you have any objection to the states, was it 1 and 2?
Judge, it's,
No.
State's 1 is a summary.
I object
And
to
then-
states 1 because I was not given the misdemeanors.
Okay, my main concern
It's
are
the
the
felonies.
felonies. And if you have the actual judgments on those, why don't we do that way, even though it might be a little more documentation, Mr. Coleman? If you will go through primarily the felonies would be my concern.
Yes, Judge.
And,
Here's where I'd like to do, Judge. I'd like to admit the summary and just the felonies as a backup, because what I want the court to refer to is the summary. I want to talk about the summary.
well, I want to talk about, I mean, I've got the pre-sentence report. So I need to know if there's something in the summary that's not in this report. That's what I'm kind of used to looking at. I've already made my notes on it. I've got highlights. So if there's something that's not on that already, let me know. If there is, then obviously I will. So are that there are 19 misdemeanor convictions on the pre-sentence report, and that I've got 8 felony convictions.
I think I don't have 8, Judge. I think that there's at least one of them that was refused. If you refer to the PSI, that first one, that burglary, looks like it was refused.
Stop, don't, let us figure it out.
Yes, ma'am.
So what I show with convictions on the PSI, I've got a 91 possession of a controlled substance. There was a probation that was revoked for 5 TDC.
Yes, Judge.
Got a 96 manufacturing delivery of a controlled substance, 1 year jail. I've got a 03 possession of a controlled substance, 18-month state jail.
I have that.
I've got an 03 from April manufacturer delivery with 6 months state jail. I've got a January of 15 obstruction or retaliation, 2 TDC.
Yes.
I've got at the same date, a harassment of a public servant, 2 TDC. I've got a driving while intoxicated, 3rd or more. Offense date of 11 of 15, 3 TDC. And then I've got an 18 obstruction retaliation with 5 TDC. That totals 8 felony convictions.
That's more than what I had in my summary, Judge.
Okay. So are there then, I need at least whatever you have, because he has pled not true to the ones alleged in the indictment, which, let me pull that up.
Yes, Judge.
There's states 5.
May I elaborate?
He
Yeah.
needs to, he needs to
Give him a
review his
second.
documentation.
The
So,
document's right there, State.
Hey, Mr. Burbank,
sorry,
you
Judge.
asked a question. Let him answer the question.
Yeah, I
Calm down.
would.
He's on it, I'm sure. Mr. Robinson?
yes, ma'am. So what I did is I took a known that he had pled true to. I used the fingerprint off of this known that was pled true to. And then I compared these documents to this document to the rest of these documents. Some of them have fingerprints, some of them do not have fingerprints. They, however, all have name, date of birth, identifiers of that nature, which is what I've compared to make these
So in-
assessments that they're all true.
Does states 5 have the fingerprint? How did you,
I was going
do
through
states
that
5?
because several of them don't have the fingerprints, but
Okay.
there are a few that do.
Go ahead. Let me also, let's kind of stop because there might be, right now, I told you to kind of focus in on the 3 that are in the indictment. The state did file a notice of intent to use prior convictions to enhance punishment back in January of this year of 2024. And so that motion lists it lists 6 felony offenses. So we obviously need to go through these 6 potentially as well.
Thanks.
Here's what I want to do. We're going to take I want to take a quick break. I'm going to take care of this other matter. Y'all go through, get it organized on the 6 that are in that motion. If any that are in that motion are not duplicative, I want to know which ones are duplicative of the ones in the indictment so that we're not talking about them twice. If there's 3 in the indictment and those are included in the motion, if some of them are, some of them aren't, be ready to tell me so I can know which ones we're going through so that I know if there's 6 that are being proved up, if there's 8 or 9 that are being 8. I show 8 on the PSI, potential felony priors. So I want to know kind of where we are on all that. Y'all can just go sit down and take a break for a minute. Don't leave the courtroom, Mr. Segur.
Yes, no, yes, ma'am.
There, because it was reduced, there wouldn't be a
I do not see an SID number, no, ma'am.
date of birth is correct. Name appears correct.
That is correct.
Investigator Robinson, is it fair to say that Mark Anthony Segur is a unique name? It's not like we're talking about a Mark Jones, if correct.
I don't know any other Mark Anthony Sears other than the one I've looked at.
Put your
on the
hand
paperwork.
down. And Mr. Segur, sitting there thinking that me asking these questions is somehow on your side
No, ma'am.
and making the head nods and all
No.
the things that are going on, you need to stop because
No.
it's not helping.
Yes, ma'am. No, ma'am.
So here's
I'm
what
a
we're
man for
gonna,
mercy.
hold on. Here's what we're gonna do. Mr. Segur, I want you to remain here in the courtroom.
Yes, ma'am.
Mr. Coleman, I'm gonna recess this hearing until 1 o'clock.
Yes, Judge.
When we get back at 1 o'clock during lunch, I need it all ready to go, lined out, whatever. If you want me to take it into consideration, now I've already taken judicial notice of the PSI, but if there are objections that this is not him, then this is what I'm asking you to do, Mr. Burbank. Specifically go through the PSI, or actually specifically go through the second amended notice of intent. And I want you to go through that, and I want to know which of those, and if it's all of them, that's fine. But if you're saying that this is not him, it's someone else, then I want to know that. If you're saying it's not admissible because of some identifying factors, I want to know that.
Your Honor, I believe that the ones that I'm arguing about are the TDC ones that I've already.
So then we're arguing right
objections
now about a misdemeanor. I want to,
Yeah.
if we're not going to argue about
to.
misdemeanors,
I'm not.
are there any on the list of misdemeanors that you are arguing that are
No.
not Mr. Segur?
No,
All right, so then, do you have any objection to my taking judicial notice then of the PSI, which includes 19 prior misdemeanor offenses?
no.
Okay, Then we can stop with all the misdemeanors. I don't even need to see those judgments. Are there any other felony I have three in front of me now. Any
States two. Judge?
states two, states
Seven,
six, and
and
states
6 and
7.
Has 6 been admitted, Judge?
I have states 2, 6, and 7. These are all 3 third-degree felony offenses that have been admitted into evidence. I have not made findings yet, but they are admitted. With regard to other felonies that you want me to take into consideration for punishment purposes, not necessarily enhancement, I know you said there was state jail that you kind of stopped on. Are there any?
There are some state jails for punishment purposes, Judge, but I think we've hit the limit on enhancement.
Okay.
felonies, Judge.
So with regard to the state jails, Mr. Burbank, it looks like on the PSI, I'm looking back now at the PSI, it appears that 2 of the several felony offenses, only 2 of them appear to be state jail felonies,
And those are back in 2003, Judge.
correct?
Where we received 18 months
And 6 months. Is there an objection
No, Your Honor.
to those, or me taking those into consideration, or any that's not Mr. Segur?
No, Your Honor.
All
There's
right.
also one in 96 that I'm not sure about. It said 1 year still, but I guess that's the misdemeanor.
That would have been
possibly.
probably before state jail. So I think that's the one that might have been reduced
Was
that
it
they were
that
talking
one?
about. So that one I'm not taking into consideration as a felony. I am taking it into consideration as a lesser included or a reduction, whatever it was, that to that jail time in county.
Judge, in that case, the state has no other evidence to
Okay.
present. And if the court desires, we don't necessarily need to recess. If you've got.
Perfect. No, let's keep going. So that means at this time, then, based on the evidence, do you have any evidence, Mr. Burbank, with regard to the findings that I'm going to make on count States Exhibit 2, 6, and 7? Comments?
There's one that I had no objection to. Was that 2, Judge?
Right. So, I mean, I know you had, I don't remember now which one, but
The ones I filed, the ones I had objection in reference that it was insufficient
Okay.
to identify. That's just my objections.
perfect. Then at this time, I am going to, based on the evidence that has been included in the PSI, as well as States Exhibit 2, 6, and 7, I'm going to find that the prior criminal offense felony in cause number 15-23847, which is number 15 in the state's enhancement, is true. I am also going to find State's Exhibit number 6, which is cause number 15-22572, which is number 14 in the state's notice of enhancement, make a finding that that is true. In addition, States 7, which is cause number 18-30235, which is number 16 in state's notice of enhancement. I am also going to make the finding that that is true. So that are those 3 prior felony offenses. I have made findings of true. I am taking into consideration all of the other ones, with the exception of states number 5, which has not been introduced, but that was, we discussed, which is cause number 60328. I am going to make a finding of not true because I don't have enough evidence in that. It sounds like in that judgment to link Mr. Segur well enough to that offense. Everything else I'm taking notice of for punishment purposes.
And I know this is minor, Judge, but does that include the 2096? Let me show you in the PSI, in which he received 1 year before the state jail.
I just said that a minute ago. So in 96,
Okay, that's the one.
I'm taking notice that that was reduced and is not a felony. So, and what that means is that it appears as though there are this would be maybe the 7th or 8th. All right. So yes, I took judicial notice that that one was reduced from a felony to a misdemeanor back on the conviction date in 97. All right. So Mr. Burbank, you may proceed with argument on sentencing.
If I may, I'd like to call my client.
Yes, and he's already been sworn in. Thank you, Mr. Robinson. Go ahead, Mr. Segur or Mr. Burbank.
We're here today, Mark, to determine what punishment should be in reference to this. Tell the court why. Well, what are you asking for in punishment? Let's start with that one.
First of all, Miss Judge West, ma'am, I'm asking for mercy, for forgiveness to begin with. I'm not a bad person. Miss West, I completed high school. I had 1 semester in college for auto mechanics. I've served for the community. I worked all my life. The kids was out playing.
Where have you worked?
I worked for Lil and Willis when I was a kid at the age 15. After that, I graduated and I continued working. I've been working in the plant for over 30 to 40 years. All my life, I've been working.
How many years?
Business scalpers and all different types of jobs all over.
Mark,
Yeah.
how many years did you serve in prison? How many years have you been in prison?
First of all,
How many years have you been in prison?
all together with everything, I done did over 10 years.
Okay, and how old are you?
I'm 58 years old.
58 years old, and for 10 years, you've been in prison in DWIs and other things. So what mercy are you asking for from this court when you have 19 misdemeanors and 6 or 7 felonies? Why should she consider something less? I mean, give her a reason why.
Miss West,
What's changed?
I didn't do half of the things that they say I did.
Mark, you pled guilty to them, okay? That's
Yeah.
over with, right? The day for you in reference to court, the day for you to say, I didn't do this is over. You accepted a plea, okay? I mean, let's cut to the chase here,
Yes,
because she could find the allegations, well, she did, the true and under consideration, and it's 25 to life,
yes.
okay? And I guess the most you've had up until this point is 5 years, correct?
Yes.
Okay, so now let's go first to when you were arrested. Were you working?
I'm receiving disability. I can't work no more.
Okay, what is your disability?
I got rheumatoid arthritis. I got prostate problems. My heart is bad.
Are you on disability?
Yes, sir.
Okay, and when were you placed on disability?
Like 2020.
Okay, so 2020, you're on disability. So while you're on disability, why are you drinking beer 40 ounces at a time? Or drinking the night before to where you're tired?
There's no
Explain
excuse.
to it.
I just lost my brother. I lost my mother and my father. And the alcohol just don't bring it. They're not gonna break me.
Okay, so you have a problem.
I have a problem.
One of the things we talked about was, when you came to me was that you never went into a program.
Never.
You never went into a drug program?
I never had a chance on probation and nothing.
Well, you got.
Well, what
revoked
about
on
when you
probation.
weren't on probation? What about the times when you weren't in prison and you knew you had a problem and you wanted to stay out of
Yeah,
prison?
well, I got a device since I've been home.
What do you?
No, what, that's since since
Oh,
you've
yes,
been in.
ma'am. I tried.
I'm talking
going-
about the rest of your life. I'm talking about the times that you got
Yes, ma'am.
arrested 43 times for public intoxication, 39 traffic offenses, 17 times you didn't appear in court, 5 disorderly conducts, 4 open containers. I mean, these are the ones that aren't even listed on the pages.
Yes, ma'am.
Pages.
Miss West, they have 5 different other marks here.
Okay, so you're gonna
In the
stick with,
system.
you're gonna stick with that this isn't you.
No, ma'am, I'm not making no excuses. I have very much high respect for the
Well,
officer of
but-
the law.
Okay. Do you
Okay.
really? You
Yes,
do?
ma'am, I do.
So that's the 19 misdemeanors, the assaults, the terroristic threats, the
I-
trespassings, the 1, 2, 3, this is your 5th DWI, your 2nd felony DWI. By what you need to understand
Yes, ma'am.
is that by not really taking personal responsibility and making us go through this circus that we've been going through now for an hour and a half of trying to prove that you actually have been convicted of felony offenses.
Yes, ma'am.
When you know darn well that you have,
Yes, ma'am.
makes no sense to me.
Yes, ma'am.
Mr. Coleman,
I have no questions for the defense.
argument.
Just briefly, Judge, you have everything you need, Judge. We're asking that you sentence this defendant to the minimum of 25 years. He put himself in this situation, Judge.
If I
Go
may,
ahead.
Judge. One of the things in reference to the priors, maybe semi my fault, Judge, because if I did not object to him, to me, it would, and he pled true to him, then it would automatically go to 25 to life without the consideration of full range. He's got a problem, and he spent most of his life in and out, and it's alcohol related. I throw one thing out, Judge, but it is alcohol, and he was in a vehicle, and there is a big risk in this. Is that you place him on 10 years deferred probation, you find true to the allegations, you send him to safety, but if he screws up, he's looking at a minimum of 25 to life if you find those true, so that if he comes back. Here's the problem is that we don't know what happens when he comes back, what the new offensive violation is in reference to this. But I have done it before, Judge, in other courts where you could give him deferred. And
I can't give deferred on a driving while intoxicated. Now, we've done that on other types of
Yes, you did.
offenses,
That's right.
but I can't do it on
Yep,
this. That's not an
absolutely
option.
right, Judge.
Okay,
So,
all right, thank you.
Yeah.
Mr. Segur, you're starting with the beginning of this hearing when we were going through the just the nature of the offense.
Yes.
Starting there, we went down the wrong path. It makes no sense. I don't believe it. It doesn't add up to what your blood alcohol level was. How you say what happened that night doesn't line up. It just doesn't. I get that 40 ounces is a big beer, but if you've been an alcoholic for as long as you're talking about, that's not going to get your blood alcohol to what it was that night, which was almost a 0.2. It was a 0.188. And I have already found those 3 prior offenses true. Those are all felony offenses from different conviction dates. I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated 3rd or more. Going to sentence you to a term of 25 years in the institutional division of the Texas Department of Corrections. In my opinion, you're lucky that Mr. Coleman asked for 25 because I'm not sure that you really even deserve that with your criminal history and with how you have refused to accept real responsibility. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive on this case. I'm going to hand you the trial court certification. This was not an agreement. You do have some rights to appeal. You can talk to Mr. Burbank about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can also talk to Mr. Burbank.
Yes, ma'am.
Good luck to you, sir. You can go back with the bailiff.
I always think it's funny when they give them 25 years in prison and they still want to tell them about you can't have a firearm. 25 years, I don't think I'd remember anything she had to say there. Linus is trying to get to Texas. I think next week. Yeah, we're a week away from whenever she leaves. Now would be the time to donate. The pinned comment has a GoFundMe link for her. Go check it out. Donate if you can. Starting next week, we'll start Linus's jail fund. And so make sure to donate to her fund to help get her home. And so Sivo girl, you were watching Judge Fleischer's court and you felt Judge Fleischer made some comments that were just weren't really accurate about some medicine. And, you know, you were trying your best to correct it, and you were right, but it wasn't the right forum for it. Me and ATX Alley have started a show called Court Addict at 9:00, where they discuss different types of aspects of that sort of mistakes that people make and the things they get stuck up on. Make sure to check it out at 9:00. We're going to go over to it. We just have a more informal discussion about medicines and drugs and just, you know, how it tears up lives and destroys everybody's world. So we're going to check that out. Yeah, Rivette saying that Linus won't be going to Florida. She won't be leaving on probation. No. And you know, it's funny. I remember whenever I was young, most everybody was done drinking by the time they were 21, because by then you couldn't drive, and you had been on probation for so long, you'd stop drinking. So, well, let's jump over to a little bit of Judge Fleischer. We've only got 15 minutes left, so let's check out some Judge Fleischer from today. Here we go.
How's it going?
Been a while. How are you? What's
Doing all
new?
Yes. It's gas.
I'm right. Thanks. Good morning, Mr. McGaskey. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. Mireles picked up a new case.
Yeah, and he came in, checked in and left saying he had other places to go.
What?
Yep. I warned him that if he left, that more than likely a warrant will be issued for his arrest.
Next time.
I can't because I'm on the technical. That's part of the problem.
All right.
But I agree.
Mr. McGaskey, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Just please don't say it. Okay.
October 26th, officer was dispatched to a major crash in Harris County, Texas. Upon arrival, the officer observed the defendant sitting in the driver's seat of his motor vehicle with his keys in his lap and with an odor of an alcoholic beverage. The defendant stated he drank prior to driving. Standard field sobriety tests were performed. HGN 4 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant consented to breath, but the defendant was unable to do the test. A blood warrant was then signed and executed.
It was really quick. So where was he?
So it was a major crash in Harris County, Texas, specifically on 2201 Southwest Freeway.
Okay, and then what?
The officer arrived and he was in his driver's seat, and the officer observed his keys in his lap, and then he observed an odor of alcoholic beverage.
Just an odor. Anything else?
And then the defendant made a statement that he drank prior to driving.
Yeah.
And that's it.
Leads you to believe that he's drunk. We have an accident, I get it, but there's just an odor of alcohol. There's nothing, no slurred speech, no bloodshot eyes, just an odor.
Yes, sir. All that was written was the odor was observed, and then the statement made about him drinking.
McGaskey, I have an accident. All I have is an odor of alcohol. What can you, other than the accident, what can you lead me to believe that he's drunk or intoxicated?
The defendant stated he drank prior to driving.
We don't know how many, we don't know how much, we don't know when it was happened.
Well, Judge, I don't think that's necessary to provide probable cause for the case. He's admitting to drinking, he's got odor of alcohol in the breath, and the accident itself is evidence of intoxication, Judge. All of that, in our opinion, is enough for probable cause.
I don't think so. I mean, usually there's a lot more than just that. An odor, we don't have anything else. I don't know when, I don't know how many, I don't know how strong it is, just an odor.
Not every case has extrapolation or admissions of how many.
I understand. I understand, Michael, but I need just a little bit more than just an odor and an accident.
An admission to drinking, Judge?
Okay, we don't know when. The officer can't do any more questions than that. Okay, when did you do it? How many did you have? Did you have anything to eat?
Understood.
Okay, all right, I'm gonna find no probable cause, Mr. McGaskey. It's very possible that they take it to a grand jury and indict it, but so I would be on the lookout, number one. Number two, you know how many accidents and death we have every day due to alcohol and getting into a car? I'm gonna find no probable cause. Just take a seat for a moment.
Judge.
Thank you, Mr. Jeff.
Page 7.
It's really great to see you.
Great to see you too. I'm good. How are you, Judge? I know. How are you doing?
Wonderful.
Good.
Who do we have here?
Mr. Figueroa, Javier Figueroa. It's a first DWI, first offense of any kind.
Morning, Mr. Figueroa. Good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On October 24th, 2024, officers were dispatched to a major crash in the 14300 block of White Heather Drive, where the defendant was involved in a single car accident. The officer observed the defendant in the front driver's seat of the motor vehicle when they arrived on scene to provide assistance. Upon contact with the defendant, the officer detected an odor of an alcoholic beverage, and the defendant admitted to drinking 7 12-ounce cans of Modelo. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 2 out of 4. The DIC was red and the defendant consented to breath. The results were 0.10 and 0.09.
What did you say the stop was for? I zoned out.
It was a
Single
one
vehicle crash.
single car accident.
All right, Mr. Figueroa, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
It's right now expired, but I'm working on it. I got an appointment next Friday.
Don't have a license.
It's expired. It was expired.
Then I'm ordering you
Yes.
not to drive. You're not allowed to drive. I don't care what's going on in your life. I don't care if there's a burning building and you have to save 50 kittens. If you don't have a license and liability insurance, do not drive. There's no quicker way to get to jail than to drive in violation of this. Do you understand? I'm telling you now, nothing chaps my boca more than when you drive without a license and insurance. Don't do it. I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using alcohol or drugs, likewise, I'm going to put you in jail. You will not get any more PR bonds. I absolutely love her to death, but I don't care however much I love her. You start acting a fool, I'm going to put you in jail in a heartbeat, in a moment's notice. Do you understand? If you are somehow able to get your license, come back to me, show me that you have your license, show me that you have insurance, and we will take this off. But until that point, do not drive. You understand? I will have you sign this affidavit promising us you're not going to drive. I'll get you to Victoria to sign a reset. I'll get you to Felicia to sign bond conditions. Then you guys are out of here. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Ms. Strauss, and she will tell you when you have to come back to court. She tells me that she can't get a hold of you. Only one thing's going to happen. Do you understand? Okay, guys. Thanks. That way. You too. Yeah. Are you Jeffrey or Joe Greathouse?
Sir.
Mr. Greathouse, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So he also has an evading arrest in a motor vehicle and an FSRA. Dead body?
No, Judge.
Okay.
No, it's charged over.
All right.
Yes, Judge. The officer attempted to initiate a traffic stop in Harris County, Texas, after observing the defendant driving a blue Corvette on the wrong side of the road. The officer could clearly see that the defendant was in the driver's seat and the witness, a female, was in the passenger seat. The defendant refuses to stop, and the officer observed the defendant to run 3 stop signs. The officer lost sight of the defendant, but heard over the radio that a blue Corvette hit a cyclist 2 lights ahead of where the officer lost sight of the defendant. The witness informed the officers that the defendant lost control of his car, hit a pole, and then hit the complainant on her bicycle. The witness stated the defendant left the scene after hitting the complainant. The officers shortly thereafter located the defendant's vehicle and conducted a felony traffic stop. At this point, the defendant was in the passenger seat while the female witness was in the driver's seat. A DWI investigation began after the officers observed a strong odor of an alcoholic beverage slurred speech, and glossy eyes from the defendant. The defendant refused all SFSTs and refused a breath sample. A search warrant was signed and executed.
Intoxication assault?
I mean, this is a fairly recent case, Judge, so we don't have any medical records or anything back, but I've been in contact with BCD about potentially.
What's the condition of the complaining witness? Do we know?
What I believe, just from what we have, just from, I think, the DIMS, is that she has a broken leg and that I know she was transported to Memorial Apartments, but that's all we have so far.
Mr. Greathouse, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to drive at all. You will be signing an affidavit with me, promising me you're not going to drive. I don't care what is going on in your life. I don't care if Jesus comes down and needs a ride to church. You drive. And every time you drive, I will have a contempt hearing. You will be facing 6 months in jail and a $500 fine every time you get into a car and drive. Do you understand? I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. In fact, I'm going to send you now for a drug test because I want to know what, if anything, is in your system. Felicia, I'd like to send him now. If you fail to go take a drug test, if you fail to come back, I'm going to make your bond extremely high. Do you understand? Prior to you leaving now, though, you will be promising me that you're not going to drive for any reason. I am also going to put a Scram ankle monitor on your leg so I know that you're not consuming alcohol. If I find that you consume alcohol, and I don't care what the source is, then likewise you will go to jail. Do you know that every single day in Houston, in Harris County, someone dies from an alcohol-related collision? Every single day, someone dies in our county because of alcohol. It is a sick, a disgustingly sick and sobering statistic. Every day, someone dies. I don't want you to say anything, but I want you to understand that I will do everything in my power. Every resource that I have, I will use at my disposal to prevent anyone from dying under my watch. And if that means putting you in jail and making your bond $500,000, I will do it in a heartbeat. All I'm asking you to do are several things. Don't drive and don't use. Do you understand? Okay, I want to send it for a test now, and then we'll have him come right back, and then we'll finish with bond conditions.
And how many days for this round?
Today. I'm going to have you swear to us that you're not going to drive, and then we'll send you for the test right now. Oh, I want to order a guardian interlock as well. That way, at least DPS has notice if he's in a car driving. He's not supposed to be. Vic,
Harris.
thanks. Good morning, Mr. Harris.
Buddy, how you doing, Your Honor?
Sir, you're charged with resisting arrest. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On October 26, 2024, the officer was dispatched to a residence in Harris County, Texas, in response to a suspicious person. The complainant stated that someone had been beating on his door for 15 minutes. While the officers were speaking to the complainant pointed out the defendant as the person who had been knocking. The complainant had a ring camera to show the defendant was the person knocking on the door. The defendant admitted to being intoxicated, and the officer advised the defendant to go home and stop bothering the complainant. The officer left, but shortly after, the complainant called back, stating the defendant was damaging property in the bed of the complainant's truck. The officer returned and attempted to detain the complainant, or attempted to detain the defendant. While the officers were reaching for the defendant's wrist, the defendant yanked his arms back twice away from the officer. The defendant was being placed under arrest for public intoxication.
Now's not the time. Okay, you will get the opportunity to fight the case. Just now's not the time. I've got a bunch of DAs here. Anything you say, they're going to use it against you. It's just not the time. Mr. Harris, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using, I'm going to lock you up. I'm not asking much. I'm also ordering you not to go back to this place. Do you understand? What do you do for a living, sir? What do you do for a living?
What I do for a living, nothing as of right now.
How old are you?
23.
You graduate from high school?
I did, sir.
Okay, so what are you going to do with the rest of your life?
Looking for a job. I had just currently moved to a new address, so I'm looking in the area for a job.
When is the last time you've had a job?
The end of May, beginning June.
Which year?
This year. I was at Pilot gas station. I was a cashier and a /field attendant.
What'd you start?
I had moved. Like I said, I moved it into a different address.
How are you getting money now? Who do you live with?
My mom and my stepfather.
It's time for you to start working.
Of course.
Too much time on your hands, you're becoming self-destructive. This is not a good way to go through life, Mr. Harris. You know, you got no job, you got no money, you got no prospects. The older you get, the harder life becomes. If you don't have a job, if you ain't got no knowledge, you'll go nowhere in life, penniless when you're 50. That's not a way to go through life. So I want you to get a full-time job. I'm making that a condition of your bond. You understand?
And sir, I do have footage of me not resisting. It's on my aunt's security camera.
Okay.
Okay, I'm just want to put that out
I'm
there.
going to appoint your lawyer today. My only concern is that you make something of yourself, Mr. Harris.
Of course, of course.
One of those statistically just nothing bums that have nothing.
I plan on going to college as well, so I will do something with my life.
Your lawyer today. I'm going to bring you back in 2 weeks, and I want to see what you've done to get a job. If you've done nothing, it's not going to go well between us. Do you understand? Okay. Let me see if I have an application. I need you to fill out an application for me. Deputy's going to give you an application for an appointed lawyer. I'm going to have you go to Victoria Sign and Reset, and then I'm going to have you take your seat in the jury box. Okay? All right.
Thank you, everybody, for coming out. Thank you, everybody, for watching. We're going to jump over to Court Addict on American Courts 2, and we're going to go over there. You guys have a great night, and we'll see y'all tomorrow.